And you started correcting my Latin pronunciation.
Oh, ultravirus.
Ultravirus.
I could be wrong, but
yeah, either
virus
way.
sounds like, you know.
I understand.
Virus.
These are very significant issues. You know, I mean, we need that one non-lawyer member because we understand the control that courts have over lawyers and how really lawyers' thinking has been, you know, there's been a process of indoctrination that they've gone through that started when they walked into the law school doors. You go in, I think the point that you're raising relates to a point I touched on earlier, and that's this interconnectedness. In 1968, Pennsylvania had a constitutional convention, and they redrafted certain provisions. There's a whole bunch of them. Among the most significant of those changes was the rewriting of the articles on the judiciary. I don't know how they read prior to 1968. I haven't gotten to that point of going back and doing that research yet. But in 1968, Article 5, Section 10 of the Pennsylvania Constitution centralized all power of all things court-related to the Pennsylvania Supreme Court. They gave the Supreme Court ultimate rulemaking authority over all disciplinary proceedings, complete and exclusive control over lawyers, over courts, over everything. You know, so I explained before that lawyers now have to go and practice in front of courts that are ultimately the arbiters of their conduct, misconduct, or not misconduct in the future. Makes it a very difficult environment for, and I've had to do it, and I know, you know, there are times where I have come out of court when I had my license and where my client was saying, well, you need to say this or you need to say that, and I would just, you know, my response, and maybe I didn't always articulate, was I just can't. Well, I can't say that. I can't do that. Because, and I never knew why. I used to think about that after I left court, thinking, why couldn't I say that? Why couldn't I do that? And what I came to the conclusion was,
it's like oppression. Because
I would get in trouble. Because it would come back on me. And you know, it's not just a personal interest of people involved. I mean, I have other clients that practice in front of these judges and they have cases, and it's easy to get caught up in that kind of thinking that you have to protect yourself and you have to protect others by not saying and not doing certain things. Well, that's a huge problem when it comes to representing individuals in courts. There should be no obstacle for an attorney to stand before a judge and say, Judge, I feel like you mistreated my client. I feel not only did you just make a mistake of law, but Judge, I really, you know, I sense by the way you spoke in court that day and you addressed me that you have some personal, I mean, I should be free to say this. And I honestly, I did feel free. I told judges, you know, I tried to do it as respectfully as I could. Yeah, but I didn't get suspended for mouthing off and being cocky, although maybe I was at times, but that just comes with being, there does have to be some legislative oversight. And unfortunately, you know, what you're getting to here is this problem, based upon my analysis of it and the heart of it in the Pennsylvania Constitution, it cannot be done without reforming the Pennsylvania Constitution. And there's two ways to do that. And this would be the most direct way, in the way that I think it should be gone about. And I mean, there's a lot of citizens that would have standing to bring this kind of lawsuit. File a suit in federal court claiming that the Pennsylvania, Article 5, Section 10 of the Pennsylvania Constitution violates the separation of powers principles and due process principles of the federal Constitution. So rather than having to convene a constitutional convention in Pennsylvania, and you know, so you have to go through a whole educational process to educate individual legislators of the need to do it, and then to get the constitutional convention, and then to get it passed and voted on. I mean, that's a several-year process. Federal court could say, Article 5, Section 10 of the Pennsylvania Constitution violates our Constitution. Boom, it's struck.
Has anyone ever challenged it? Do you know, on the record, if there's any cases where anyone has actually challenged this?
That King's Bench petition that Don Bailey filed that was decided in less than 5 business hours, I believe it was.
Supreme Court of the United States, isn't it? What level would you have to go to with it?
Start by filing a federal civil action in district court and asking for injunctive relief, a declaratory and injunctive relief. I'm seeking a declaration from this court that that section violates Article 5, Section 10 of the Constitution. Therefore, you got to exercise your equitable powers to restrain any further proceedings. An issue like that certainly would then go to the, either losing side in a case like that would appeal to the Third Circuit Court of Appeals. That's your one appeal as a matter of right. And then it would be within the certiorari jurisdiction, discretionary jurisdiction of the United States Supreme Court. But
how do you get something? So few cases are heard by the U.S. Supreme Court. How would you rank this in importance? You think it would get in front of them?
Well, given that the United States Supreme Court is on a little bit of a different footing. It is the only federal court that is established by the Constitution. Every inferior federal court, every district court, every court of appeals derives its authority from an act of Congress and not from the Supreme Court itself. We're going to talk about some issues in Don Bailey's case that, again, sometimes might sound a little conspiratorial, theorist, but the United States Supreme Court, unfortunately, and I think thanks to Bush v. Gore, the decision in 2000, that Americans in large part have woken up to the fact that that institution is not at all above politics. You see it come across in the landmark cases that come through. There's a Chief Justice, John Roberts. Chief Justice is the agenda setter. John Roberts was appointed to the Supreme Court as Chief Justice. He came, I think it was from the D.C. Circuit, if I'm not mistaken, and elevated right to the Supreme Court, and elevated right to the Chief Justice position, vacated by deceased Justice Rehnquist. So he's an agenda setter, and that's where the politics in the Supreme Court, it comes in setting agendas.
What do you mean by that?
Well, it's going to get complicated, but I'll give you, and I understand that there's going to be a wide audience for this, and there are things that Don and I talk about from time to time, but the most recent, not the most recent, the third most recent justice now, I guess, Samuel Alito, he came from the Third Circuit Court of Appeals, which is out of Philadelphia. Don and I both practiced, argued in front of him. He was familiar with our cases. Two of our cases, one of mine and one of his, I believe, at least I'm told, came up during his confirmation hearings. And he has authored a couple of authored or voted favorably for a couple whistleblower opinions that have severely limited the rights of public employees when it comes to reporting official misconduct. Don also had the case where he got the $1.5 million verdict against Attorney General Mike Fisher. No one in the state of Pennsylvania has heard about this case. But when Mike Fisher was Attorney General, Don Bailey got a jury verdict on a whistleblower case where they mistreated and abused some narcotics agents out of Philadelphia because of the sensitive information of who was dealing drugs in what official positions and things of that nature they came up on. I do not have intimate knowledge of the facts of that case, but I know that in February 2003, maybe, a jury in Luzerne County came back with a verdict in their favor. This is important. This relates to that question, the question that you're talking about. What happened was, Mike Fisher was a sitting Attorney General.
I remember the name.
He now is a judge on the Third Circuit Court of Appeals. So Don Bailey filed a lawsuit on behalf of these clients, went through federal district court. For years, it was a saga. Don was getting abused and ridiculed for filing this lawsuit, and nobody else, would help him.
Narcotics agents?
These were the narcotics agents out of Philadelphia. Good guys, excellent police officers who had their careers and their reputations stolen from them because of the information that they had about misconduct, official misconduct. And there was evidence showing that Mike Fisher himself was involved in the effort to retaliate against them.
He got bumped up into being a judge anyway.
And he got bumped. He goes from Attorney General. He lost the gubernatorial election that year, whatever year that was, the preceding year or the following year. Ed Rendell wins. Ed Rendell's wife is on the Third Circuit Court of Appeals. Mike Fisher has a $1.5 million verdict against him for being a civil rights violator. he gets appointed to the Third Circuit Court of Appeals where Ed Rendell's wife is, then that court takes away the $1.5 million verdict. And then a couple years, and this was a whistleblower case. And then a couple years later, and there's other connections, you know, to this.
If there was, they won a verdict of $1.5 million against the attorney, just
among others, Attorney General.
Is that actually like you're suing a public official? Are you suing the state? How does that go? Don't they have immunity? I mean, how was he able to? There's
immunity issues involved, but you know, a state official, the official, him or herself, only has what's called a qualified immunity. And I believe
the ultra vires, they acted outside their.
Well, not really. A qualified immunity is a little bit different character than that. You know, once a right is clearly established, so that any reasonable official would know that that's the right and that their conduct would violate that right, well, then you don't have qualified immunity. And I think, you know, again, I'm not an expert in this case. I haven't litigated it. I didn't participate in it, and I haven't studied it. But that's what I would assume the analysis would be. Yes, there are qualified immunity issues, but yes, you know, these are lawsuits under Section 1983, which gives an individual citizen a right to go into federal court and you know. The Mike Fisher, during his confirmation hearings, there was considerable discussion about this lawsuit that he had against him. Senator Leahy out of Vermont in particular was concerned, and he talked about it on the floor. And they talked about how they wanted to bring in these narcotic agents, and I believe that they wanted to bring Don Bailey in before the Senate, and to have them testify about this. And through some procedural rule or mechanism or somehow, they cut off all debate on that. They passed Mike Fisher with a $1.5 million jury verdict against him for violating an individual citizen's American rights.
He became a Third Circuit judge?
His reward was becoming a